The Supreme Court is this morning handing down its judgment in the appeal in Zabolotnyi and the Mateszalka District Court, Hungary. This case concerns conditions in Hungarian prisons and the approach which the courts in this jurisdiction should adopt in extradition cases when assessing and relying on assurances as to those conditions. In 2017, the respondent to the appeal, the Mateszalka District Court, requested the extradition of the appellant, Mr Zabolotnyi, from the United Kingdom to Hungary pursuant to an accusation European Arrest Warrant. The warrant alleges that, conspiring with a public official, Mr Zabolotnyi fraudulently applied for and then received a Hungarian passport in the name of Zoltán Dani. In the United Kingdom, extradition to EU countries such as Hungary is governed by Part 1 of the Extradition Act 2003, which gives effect to the Council of the European Union Framework Decision on the European Arrest Warrant. The 2003 Act has been amended to reflect the United Kingdom's withdrawal from the EU. However, since Mr Zabolotnyi was arrested before these amendments came into effect, they do not apply in his case. The appeal has therefore proceeded on the basis that Hungary is a designated Category 1 territory under Section 1 of the 2003 Act. The European Arrest Warrant requesting the extradition of Mr Zabolotnyi is in the correct form and contains all necessary information. However, Mr Zabolotnyi resists extradition because he says that there is a real risk that he would be held in Hungary in prison conditions which amount to inhuman or degrading treatment, contrary to Article 3 of the European Convention on Human Rights. Concerns about Hungarian prison conditions are nothing new. In March 2015, the European Court of Human Rights upheld a number of complaints against Hungary of inhuman or degrading treatment arising from overcrowding in Hungarian prisons, in particular relating to the lack of personal space in cells. The European Court of Human Rights considered that there was a recurrent structural problem throughout detention facilities in Hungary. In other decisions, that court has made it clear that, to comply with Article 3 of the European Convention on Human Rights, every prisoner should normally have at least 3 square meters of floor space. In September 2017, District Judge Snow ordered Mr Zabolotnyi's extradition to Hungary. District Judge held that Hungary had taken significant steps to improve its prison estate and to reduce overcrowding. He was therefore satisfied that the presumption that Hungary was compliant with Article 3 ECHR had been restored, and that there was no need to ask for an assurance from Hungary to confirm that Mr Zabolotnyi would not be held in overcrowded conditions. Mr Zabolotnyi appealed to the Divisional Court against the extradition order. Before his appeal was heard, the Divisional Court held in another case, Fuzesi against Hungary, that assurances in respect of prison conditions were still needed to permit extradition from the United Kingdom to Hungary. As a result of this decision, the Hungarian Ministry of Justice provided Mr Zabolotnyi with a personal assurance that he would be held in conditions which guarantee him at least 3 square meters of personal space in one of 2 modern prisons, Szombathely or Tishalok. These prisons are said to conform with the space requirement laid down by the European Court of Human Rights, as well as providing better conditions generally. At the appeal hearing, Mr Zabolotnyi applied for permission to rely on fresh evidence, which had not been available at the extradition hearing before the district judge. The evidence comprised reports of Dr. András Kadar, which alleged that Hungary had breached the assurances it had given to others extradited to Hungary. The reports are based on accounts given by individual prisoners, 3 of whom were extradited to Hungary from the United Kingdom, and 2 from Germany. The Divisional Court refused to admit Dr. Kadar's evidence and dismissed Mr Zabolotnyi's appeal. One of the issues before the court was whether it could consider evidence concerning alleged breaches of assurances given by Hungary to a state other than the United Kingdom, such as Germany. The court held that it could only consider evidence concerning alleged breaches of assurances given to third states if it was satisfied that the evidence was manifestly credible, directly relevant to the issue to be decided, and of real importance for the purpose of the court's decision. The question for the Supreme Court in this appeal was, therefore, whether there is any such heightened test for admitting evidence concerning alleged breaches of assurances given to a third state. The Court unanimously holds that there is no such heightened test. Instead, the evidence should be evaluated in the same way as any evidence of a breach of an earlier assurance given to the United Kingdom. The European Arrest Warrant is designed to create a simplified and accelerated procedure for extradition between EU member states, and is based on the mutual trust that exists between them. The authorities establish that, in cases where the state requesting extradition is an EU member state and a party to the European Convention on Human Rights, there is a presumption that the state will comply with Article 3 and its other human rights obligations. The same presumption of compliance applies to assurances given or endorsed by the issuing judicial authority in EU member states regarding the prison conditions in which the requested person will be held following their extradition. However, the assurance given to Mr Zabolotnyi was provided by the Hungarian Ministry of Justice, which is a non-judicial authority. It was not provided or endorsed by the Mateszalka District Court, which is the issuing judicial authority in this case. This means that the court is required to evaluate the assurance and to examine and assess the available evidence which relates to it. In deciding whether an assurance can be relied upon, evidence of past compliance or non-compliance with an earlier assurance will obviously be relevant. A state's failure to fulfill assurances in the past may be a powerful reason to disbelieve that they will be fulfilled in the future. There is no meaningful distinction to be drawn here between assurances given to the United Kingdom and those given to another state. In any case, there can be no justification for adopting a different test for the admissibility of evidence of a breach of a prior assurance given to a third state, or for otherwise limiting the ability of an applicant to rely on such evidence. If the evidence is relevant and probative, it should therefore be admissible. The weight to be given to it is a matter for evaluation by the court, having regard to all the circumstances of a particular case, and bearing in mind that cogent evidence is required to rebut the presumption of compliance with Article 3. Despite this, the Supreme Court dismisses Mr Zabolotnyi's appeal. This is because the appeal was brought under Section 26 of the Extradition Act 2003, which means that the Divisional Court only had the power to allow the appeal if all of the conditions in Section 27 subsection 4 were satisfied. The condition in Section 27 subsection 4b is particularly restrictive because it requires the court to be satisfied that the fresh evidence would have resulted in the district judge deciding a relevant question differently, so that he would not have ordered Mr Zabolotnyi's extradition to Hungary. The Divisional Court refused to admit Dr. Kardar's evidence, but it considered it de bene esse, that is, on a provisional basis. In practice, this difference in approach does not matter, provided the evidence was properly evaluated against the criteria in Section 27, subsection 4. In the Supreme Court's view, the Divisional Court correctly applied that test and came to the only conclusion open to it. Dr. Kardar's reports could not have been decisive in Mr Zabolotnyi's case, not least because the allegations it contains were hearsay, so their reliability was incapable of being tested. The fresh evidence was not therefore sufficiently cogent to be capable of rebutting the presumption that the assurance provided to Mr Zabolotnyi by the Hungarian Ministry of Justice could be relied upon, nor did it require the Divisional Court to request further information from Hungary pursuant to Article 15, paragraph 2 of the EU Framework Decision. This means that the condition in Section 27, subsection 4b could not have been satisfied. In these circumstances, the Divisional Court was bound to dismiss Mr Zabolotnyi's appeal, and the Supreme Court now does the same. The district judge's order extraditing Mr Zabolotnyi to Hungary is therefore upheld. The court is now adjourned.